Good. The glitch is resolved. That was something.
Yo, guys, I actually started the seminar. I didn't know we didn't go live, and I was here talking.
I think we were.
But viewers, I'm so sorry, guys. We had a little bit of technical difficulties, in getting this episode running. But tonight's a big night. It's a really big night. It's the 50th episode of the Wednesday webinar, Property Law Alliance. 50 episodes. That is quite an achievement. So Cilna, well done. Bruno, well done. How do you guys feel, Cilna? 50 episodes, my goodness.
Well, I must say episode 50 came in and did what a bunch of others did. Technical difficulty, but I must say this was one of the more impressive ones. So thank you, Zoom and Facebook, for allowing us to celebrate our 50th episode with a little bit of technical frustrations. But I'm very excited. I really didn't think, I honestly didn't think I can stick to doing the same thing on a Wednesday evening for 50 episodes in a row. I'm actually pretty impressed with us. Thanks, guys.
You must love the company.
I really do. I really think I do. Oh, I'm a sucker for punishment. I'm lying. I love you guys.
No, but congratulations, guys. 50 episodes. It's no small feat at all. And it's 50 episodes of sharing such invaluable knowledge with our viewers. And Bruno, man, 50 episodes of seeing your face. I think when you started this, did you have hair?
Yes, I did. I really did.
It was the way
the age is showing, apparently. But yeah, no, it's really cool because, thinking about it, the reality is it's 50 episodes with the viewership having increased, questions becoming more and more more and more serious, different. There being a variety of different things being asked. Sometimes we can't even get to questions, so we're getting a decent amount of questions. Looking at the views of the specific videos, it's also quite impressive where, the amount of time that people are actually spending watching it, the comments on it. So it's I love the fact that we're contributing to people who actually want to watch. I mean, anyone can make a YouTube video, anyone can do a seminar. I mean, you can speak for 15-20 minutes, but if no one's watching, it's kind of sad, unfortunately. But with us, the beauty is, like, we started off with the whole COVID conversation on how are we dealing with this, how are landlords going to cope, how are tenants going to cope, what are we going to do? And it was essential. It became a crucial part of this property investors and owners. And since then, it's become useful. People are noticing. People are wanting us to get involved more and more with things. I mean, we got invited to get involved with Investor of the Year awards, Property Investor of the Year awards. I mean, that's big. That's people are starting to benchmark our styles of practice, our advice, the way that we do things. They're starting to use it as a benchmark against other attorneys. That's big. So yeah, 50 episodes. Yeah, it's done a lot. It's 50. It's over this 50 episode period. A lot has actually happened, and yeah, so I'm very proud of it. Thank you so much, Cilna. Thank you, Greg, wherever you are.
He's watching over.
I just need to say, for everybody who's wondering, Greg is alive and well, don't stress.
Like, I miss you, man.
No, but seriously, guys, no small feat. But also to our viewers who will consistently, keep us going, post the questions in the group. Thank you to you, because if it wasn't for you, we wouldn't be here. So yeah. Let's on that note, let's get underway with our 50th episode. Hopefully there are no more glitches within this one. But I've got a really interesting question. Cilna, you want to add something? Sorry,
Chris, just before you start, the only other thing I just wanted to quickly touch on, just wanted to send my condolences. I don't know if you heard, Cilna, but I saw today, apparently Jacques Tarica passed away.
What?
Yes.
No.
Yeah.
Don't surprise me with stuff like that.
I only saw,
so do my best to not cry.
So I just want to send my condolences to his family, to I mean, he was an incredible person. I practiced with him for years. We were constantly supporting each other. We had, tons of chats, and so my condolences. He is going to be missed. He was a fantastic attorney. He contributed a lot to the fraternity, so he's one of the good guys.
Yeah, and the Joburg Attorneys Association, I mean, for years, Jacques Tarica is a key player whenever there's anything with the sheriffs. Yes, definitely from my side as well. Sincere condolences. I'm a little shocked with the news right now, but and to his firm obviously and everybody. Sure, that's a major loss for the legal fraternity.
Yeah, absolutely.
Sure. So sorry, guys, for the loss, for everybody's loss, actually, from what we're hearing. On that somber note, Bruno, let's get underway. Okay, so the first question is posed by Lungile, and Lungile asks, I bought a house with my cousin, and he's falling behind in the bond repayments, and she wants to know what steps she can take, because by the fact that he's falling behind on his portion of the bond repayments, it's causing a bad credit record for her. What can she do? She's seeking assistance here. So I think, Bruno, let's throw this one to you.
Cool. So joint ownership of land is one of the hardest things to deal with, because people don't realize its implications when they first get into any transaction, right? So the logic behind it is, you know what, let's invest in something. Let's just buy it together. It seems intuitively smart. Let's buy it together. Let's share the risk, hedge the risk, so we don't need to carry it all by ourselves and stress all by ourselves. It's a learning experience. You guys do the journey together. Very often, it might even help with affordability, because one of you might boost the other one's affordability, so the banks might actually be more willing to give money. So it's a big thing. It's an excellent way of approaching it. The only problem and the only issue I have with the concept of joint ownership is people think it stops there, and it's really something we have to look at it from a commercial perspective. And I keep saying the same thing, even when one approaches things like marriages, there's always this commercial element to it that one does need to consider. With joint ownership, I actually prefer to approach clients with the concept of joint venture as opposed to joint ownership, right? Because it's a broader concept. Joint venture speaks to the asset that's coming into the venture. That's great, but it also speaks to how the investment's going to be carried out, certain terms, what is the intention of the parties, how do you enforce this intention of the parties, and there's a whole bunch of concepts that go behind, that govern how you guys intend dealing with it, especially now when it comes to the questions of default, because now I'm making an assumption here that they're joint owners and somehow they managed to get a bond together, so they're jointly and severally liable, meaning that at the end of the day, the one person has to pay even if the other one isn't. Because when the bank eventually comes after both of them, they're going to pick one person to execute first on, obviously after the house is sold. But the reality is summons gets issued, judgment gets taken, judgment gets listed against both your names, right? So that's bad. That's already a terrible thing. Property gets sold, so that impacts both of you. If the bank decides to then execute after the property gets sold, again, the bank's going to pick one of you. And if you happen to be the person that shows the greater affordability or the greater asset base, the bank will naturally come after you. So for instance, if you've got other properties in your name and your cousin doesn't, the bank's not going to say, well, it's only fair that we go after both of them equally. The bank just wants its money back and goes, well, if you want to collect from your business partner or whatever the case is, you go for it, right? So that's the one thing about joint ventures that I like to consider. Now, joint ventures is it's a broad term, and it covers a number of different types of relationships in our law. So legal aspects, such as a joint venture can be in a company. A joint venture can be in two individuals' names. When it's in two individuals' names, we need to look at how the relationship in these with these individuals involves. Can one call it a partnership, for instance, right? Can you dictate that certain terms apply to this partnership. Because in that instance, if one can say that there was a commercial basis for the transaction, that let's consider it to be a partnership between these two people, you can start looking at the possibility of dissolving this partnership. And by dissolving the partnership, you could look at liquidating the property, which means basically selling it, collecting the proceeds, separating it between the parties, obviously paying off its creditors, and just getting it done. So you get rid of the property. Short of dissolving this partnership, you wouldn't be able to try and enforce any rights of, I want the property for myself, you take nothing, or forcing the person to buy out. Because things like that, unfortunately, if not pre-agreed, is very difficult to now all of a sudden start enforcing. So your best bet in this case would probably be to try to dissolve this partnership sooner rather than later, get rid of the property and walk away. If there's a shortfall, speak to the bank. The banks, more often than not, are willing to allow the properties to sell for slightly less. They're willing to get AOD signed. So it's not all doom and gloom. There are solutions and ways to get out of this.
No, thanks, Bruno. Thanks for that. I think I'm going to quickly move along to the next question, and this is so nice for you. It's a neighbor law issue. And the viewer who asked the question says that she had purchased a property, and flanking her on either sides were brothers who own the properties, her neighbors. They're both brothers. And she says that she's been having issues for a very long time with regard to the trees on their properties. And she says that these trees are dying. And in the past, she's experienced portions or parts of the tree branches falling down onto her house, causing structural damage. And more recently, parts of the tree, these dead trees, have been falling down onto the vehicles in her driveway, both hers and her husband's. She's now asked both these brothers on several occasions, to sort this problem out with these dead trees. And they've indicated to her that if she wants to sort it out, she needs to take the responsibility and cut the trees from the skyline down. She says that that's not going to help because these trees are dead. And even if the trunks fall, they still run the risk of experiencing structural damage to their property, to their vehicles. And she wants to know, what rights does she have in this particular case? And can she enforce, certain, obligations upon these brothers who live, flank her and live next door to her? Cilna?
Yes, so it's a really good question. And I really spent some time thinking about it during the afternoon, because the problem, or at least the joy in some cases with the law, is the fact that you have legal rights, or the fact that you have legal remedies, doesn't mean it will just be enforced without judicial oversight or a court order or something like that, or some administrative action of sorts. And so initially I tried to find a way from the municipality side to assist with this. Unfortunately, because the trees are on the individual's earth, the municipality can't enter that and do anything about it. It's like the municipality can obviously, water and electricity can enter your earth to deal with that, but other than that, they can't. They can't come in and cut off your trees inside your earth. It's not going to happen. So municipality, unfortunately not. And then I thought, what else do we have? There's definitely, in terms of our neighbor law, definitely an obligation on a neighbor to ensure that there's no damage caused by your property to your neighbor's property. So the fact that she has suffered damage in the past is actually a good thing in a way, especially in an instance where she suffered damages and she tried to claim it from the neighbors, and the neighbors aren't forthcoming in resolving the problem, aren't paying for the damage. And even more so, if she obtained a judgment against the neighbor and they can't execute that judgment against the neighbor to repair the damage that was caused, I do believe that this viewer has a particularly strong potential of success to obtain an interdict against these neighbors, compelling them to remove the dead trees. For them to say you can remove from the skyline is I'm sorry, I do in a way hope these neighbors are listening to this, is the weirdest thing. You can't remove a tree or just say, trim the things that's bothering you. If a root, if a trunk falls over with the roots and everything, the kind of damage that you are causing to the wall, to everything around it, is too big. You can't send in a chopper to pull out a tree. You can't expect that from the neighbor. That's I'm sorry, but silly. So a nonchalant attitude from a neighbor is very unfortunate, because even though this viewer does have a right that she can enforce, and she does have a remedy to enforce against the neighbors, it's going to have to go through a court process. My recommendation in this would be to do a letter of demand, demanding that the neighbor remove these dead trees within a certain time period. Don't give the neighbors 7 days to do this. I mean, for me to try and arrange anything to, you know, have tree fellers come in, it takes some time. It's like a 2-3 week process. Give the neighbors sufficient time to do this. Even a month might be a little short in my head. It would be legally allowed to do that, but be practical about it. To give somebody 2 weeks to remove their trees, they need to budget for this. It's a cost. There's definitely a cost factor. Otherwise, why isn't the neighbor doing it? So have the conversation first and say, you know what, the kind of damage that it's going to cause to my property is going to be to this value. If you don't have the money for this, can't we maybe pool resources to get this done? The obligation is 100% on the neighbor to do this. I'm being practical about it and a bit more pragmatic about it than just saying, well, it's the neighbor's problem and the neighbor doesn't have money, so he can't do it, so now we must go to court. That doesn't make sense. To go through a court application like this, you're going to spend a good, let's call it 50 to 60,000 Rand on a court application like that anyway. So why don't you rather consider negotiating with the neighbor, asking if you can maybe pool resources instead of going through a court case to get those trees removed. But if it's a stubborn neighbor and the neighbor really doesn't want to budge, then the only option would be a letter of demand, give him a reasonable time period to have the trees removed. If he then doesn't, you can approach the High Court. You definitely do have a right that can be enforced. If there was damage in the past, I can't really see that we're going to get to a point of irreparable harm, being able to prove irreparable harm. But at the same time, our Lord doesn't expect you to sit and wait for damage to hit you, especially because there has been 2 occasions where this neighbor suffered damage. And definitely, you would have the opportunity to go to the High Court and obtain an interdict. Know that when we say that, an interdict isn't something you don't walk to court and be like, hey, my neighbor's trees are going to fall over. Can I get an interdict? And the court's like, yeah, of course. Here you go. Here's a piece of paper, and tell them to remove it. It's a process, and it can be a 1 to 2 year process if the matter becomes defendant. Then you have to bring in expert witnesses to, you know, attest to the fact that the trees are dead and causing damage. So a court application is definitely your last resort. My solution would be, instead of spending money on lawyers, I'm sorry, Bruno, I'm selling our potential clients away here, but I'd rather do that. I don't think lawyers is your best bet on this one. I would say sit down, have a cup of tea, see if you can pool resources, because that's probably the reason for the problem, and follow a slightly more pragmatic approach there. But in law, you would be able to get an interdict. I don't think that's the first prize, though.
Thank you. So I just want to find out something from you. Does it have to be 3 fellas? Can it not be 2 fellas? You said it's a little bit of a tree cutting jokes right there. I actually had a question on that, which was around, if I see I'm standing in my property, my neighbor's tree is about to fall on my car. My neighbor tells me, hey, listen, you cut that thing. And then I'm like, well, no, I'm not going to cut it. And then it falls on my vehicle. Now, didn't I have an obligation in that sense to mitigate, or at least to reduce the risk of that thing falling on my car? I don't know if you covered this, but But can we just touch on that quickly? I mean, because now I have to go and cut that because I've got to ensure that that's not going to fall on my car, on my vehicle.
Well, you can't cut it. Remember, in our previous neighbor law discussions around trees, you can only cut the branches that's hanging over the wall to your side, but it's still the neighbor's branches. So then you return it politely to them, which would probably, if you put it on their front porch, would motivate them maybe the next time to do the removal themselves. But to remove the car, definitely. To do everything in your power to mitigate your damage, definitely. And in a case like that, where the tree is hanging, you know, and you can see somebody's going to die or the house is going to crumble if that happens, now you have grounds for urgency, and you can approach a court on an urgent basis, but then it should be like super proper urgent, not just like the wall is going to, you know, be scraped. It's going to have to be a proper problem. And then you would have grounds for urgency. So move the car quickly. Do you want to go? Should we pause?
Thanks, Cilna. Let's quickly move on to the next question. This question is around Airbnb, interestingly enough. And the question goes, I would like to know at which point does a short-term rental become a long-term lease? Is there a stipulated time frame? And attached to that, how does the rights of tenants and guests differ? By way of an explanation, this particular viewer has a cottage that they use for short-term rentals on Airbnb. Recently, the viewer says they're getting requests for long-term leases, that being more than a month in terms of stay. Legally, at which point is it no longer a short-term rental, and at which point does it become a lease? And what are the legalities in terms of the rights, in terms of the viewer's rights, and what do they need to be aware of in this particular instance? Cilna, I think we'll throw this one to you.
Yes, I'll start on that. Airbnb part I'm going to throw to you, Bruno. But sure. The terminology, I'm more than happy to explain. Long-term lease is the wrong term here, so apologies for being that blunt. A long-term lease in terms of our law is a lease agreement that is for a period of more than 10 years. A long-term lease does have to be registered, and there are very specific rules when it comes to long-term leases. So be very careful. I get that this is not what the viewer is talking about, but be very careful when it comes to use of the term long-term lease. The difference there is once it's registered, it's a notarial, it's done in terms of a notarial deed, then that personal right becomes a real right, and it's a much stronger right. So it's not a long-term lease. So please don't confuse your terminology. A short-term lease is actually also not a thing. A lease agreement is a lease agreement. The essentialia of a lease agreement, so what makes an agreement a lease agreement, is A, that the landlord will give the undisturbed use and enjoyment of the premises to this person. The tenant will pay rent in return for the use and enjoyment of the premises, and this use and enjoyment must be temporary. Now, in all of that, that is a lease agreement. It doesn't say the term must be for this, more than a month or more than 2 weeks or whatever. Even a 2-day lease agreement complies with all the essentialia of a lease agreement. It is a lease agreement. A long-term lease, a 10-year lease is something very different. The terms must be the same, essentialia must be the same, but now it must be registered. So move away from that, and I'm going to leave long-term leases now in that little box and not touch it again. A short-term lease, the thing that makes that different is the application of the Prevention of Illegal Evictions Act. If somebody is renting a property for 2 days, but it is for business, or you're going to a braai with family and you don't want to drive back and you're only renting the place for 2 days, it's still a lease agreement. But the difference is, by definition, this person, the tenant that's renting the property, does have a permanent place of residence that is not this lease agreement. And for that reason, your typical short-term rentals, for instance, Airbnb, holiday rentals, and those things, if we have to do an eviction of that tenant, we don't have to do an eviction in terms of Pi, because they do have not alternative accommodation, they have an actual house with their stuff, where your cat is. That's how you know where you live. If you don't have a cat, we can still evict you without following the provisions of Pi. But the difference is, does this person rent this place as their place of residence, or is it temporary accommodation? That's the difference. So there's no time frame. You can rent a place for 6 months in Airbnb, and you still won't have the provisions of Pi applied to that agreement, because your cat is being taken care of the neighbor, and you still have a place where you live. So the time period isn't relevant. Only when you get to 10 years, then it becomes relevant, then it's a long-term lease. But other than that, a lease agreement is a lease agreement regardless of the term of the agreement. And the rights and obligations in terms of the Rental Housing Act and Pi would be exactly the same. But like I said, if you have another place of residence, Pi will not apply if we have to do an eviction. But that was me on that. And there was actually a long Airbnb question that I didn't even touch on. So Bruno, you're welcome to do that.
So maybe just to move this along the Airbnb route, so Cilna explained quite well the differentiation between so-called long-term leases, which are just what we consider to be normal leases in the day-to-day practice, 6 months, 1 year, or whatever the case is. Now, what's interesting is now we get into a completely different conversation. Now, I think this is where maybe and the viewers will appreciate the plight of attorneys in general, because our whole answer is now wearing different hats as we give you the answer. So are we referring to common law? Well, here's an answer for common law. Are we referring to Rental Housing Act? Here's an answer for Rental Housing Act. Are we referring to Pi? Here's an answer for Pi. So now, interestingly enough, we start looking at the Tourism Act, right? And the Tourism Amendment Bill and Cape Town bylaws on short-term letting. So now these things have started trying to establish how short-term letting is supposed to be dealt with. So Cape Town decided to go, oh, hold on, wait, we're going to exclude Airbnb or short-term letting from the ambit of, what's regarded as tourism, provided that certain prerequisites are met. So they've kind of allowed for people to rent out their houses, and they consider 30 days to be short-term, the short-term. In terms of Rental Housing Act, if one just borrows a type of definition, if you want to put it like that, Rental Housing Act recognizes leases on a month-to-month basis. Naturally, it's almost defined as an indefinite lease that carries on a month-to-month basis. So again, we're looking at about 30 days, something less than 30 days, possibly, could be argued to be short-term. Now, whether this is relevant or not really comes to the fact that how does it apply to the different forms and regulations? Rental Housing Act, it would apply. Evictions, like Cilna mentioned, it wouldn't apply. So Airbnb, guys, that's one of the things behind it. There was a Camps Bay a story or scenario the other day where this was the question that was posed, where guests had, if I'm not mistaken, the Camps Bay one was actually a protest. So they intentionally moved onto the property. They decided they wouldn't want to move out. And it was, sorry, I can't actually remember what the protest was about. It's clearly did not work very well, if you can't remember, but that's not the point. The point is that they moved onto the property, refused to vacate, and the question was posed, do we have to follow Pi to evict them? Now, as we've spoken about at length, the process for Pi is a bit stricter. It's got a lot of hoops that we need to jump through. So at most of the time, we want to try and avoid it if possible. So something like this, for example, would allow us to actually remove the occupiers through court order. No one's saying that you can skip court, but you can remove the occupiers, typically speaking, through a court order, just by applying and asking and not having to follow the provisions of Pi. I mean, I know people, for example, in hotels that would just disconnect key cards, and that, for example, wouldn't typically be your spoliation, because that's how access is granted to many of these places. So you're not dispossessing anyone. So it does work slightly different how you interact with these tenants. The longer it goes, the tougher it becomes, because the longer they stay there, obviously the more permanent the residence could be. So as long as you're very clear when entering into that contract that it is not intended to be a place of residence, that this is purely temporary, and they're going to move to someone that they have a place that's more permanent, I think you'd be safe. But jumping between the two and getting long-term short rentals, if you want to put it like that, it happens all the time with students come from overseas and they hire a place out for a year. The bottom line is they do still have other places to stay. So the rules would typically apply. You still have to be mindful of the Rental Housing Act. You'd have to have agreements. You'd have to follow most court processes. But yeah, for the most part, things would typically stay the same.
Thanks, Bruno. I'm actually now thinking about selling my house and protesting in Constantia or somewhere out there. If you want to join me, you guys want to join, let's do it.
For a weekend.
For a weekend. Just for 1 weekend.
For a long,
we still need to come back
a long
host.
weekend.
A long weekend, yes. We still need to come back and
what
host the
are we
seminar.
protesting exactly?
We'll find something.
We'll find something, Bruno, yeah.
I can find something.
Anyway, guys, let's move on to our last question for the evening. And this question was asked by Hayden Edwards, and it says, it's with regard to share block schemes. And he wants to know, how does one sue for outstanding levies? Because the viewers heard that, you could bring it via a high court application. Also, the viewer wants to know, as one has no right or title over the land, only the use of it, can one deny access to owners or demolish derelict properties? I'm sorry for the way I asked that question. I'm trying to read as one and as myself at the same time. So, Cilna, can I pass it on to you?
Yes, you can, definitely. The problem is if you are an owner in a share block situation, well, like the viewer said, you're not an owner, you're a participant. That's a good word. Can I use that? I'm very impressed. We can maybe protest share blocks. That's why we are going to Constantia for the long weekend. So because you don't have a right of ownership, you only have a right of use on certain occasions. You don't even have the right of occupation unless for a specific time within specific framework. Now, I don't have to say this because I think everybody can see on my expression that I'm not a fan of a share block setup, simply because it's a very expensive way of not owning anything. And I don't think it's that was the worst way. That was the new definition. That's like dictionary vibes. But I don't think it's a very safe way of trying to get access to a property. But here we are now. So the owner of the share block would typically, the whole share block system is obviously governed by legislation. That's a very true situation. So it's a real thing. It's very legal and it's very doable. But the memorandum of incorporation or the code of conduct or the constitution, whatever forms the basis of how the share block system is run, that would be the thing that would tell you how to collect arrear levy payments. You can go to the High Court for an application for basically anything, including this. The problem is locus standi, so who would be able to go to court? And another owner doesn't have a strong enough right to collect the levies on behalf of the other participants. I'm not even going to use the term owner, the other participants in the scheme. The only people that would have locus standi would be the owner of the share blocks situation, and that would be the only party that would be able to claim arrear levies from the non-paying participants and owners if there are owners adding their properties to the share block scheme. So unfortunately, you as a participant in a share block situation would not have the right to collect levies or payments on behalf of the share block against the other participants or owners. Bruno, did I say that diplomatically enough while answering the actual question?
No, I believe you did. And it's the same problem that I've noticed before. With sectional titles, it's so much nicer to actually be able to have legislation that governs how things happen within like sectional schemes and things like this. With share blocks, it's multiple legislation that has to govern it. So now you're looking at Companies Act, you're looking at shareholder rights, you're looking at memorandums of incorporation, you're looking at shareholders agreements. So sure, maybe you could set it up in such a nice, neat way, but it's difficult because you're running this like in a corporate environment with people that aren't looking to be in a corporate environment. Yeah, you're not looking at issues regarding share transfers, where now you're worried about whatever TRP regulations. So it's just things like that it does make life a little bit difficult, and the popularity has declined completely. I mean, as last time I checked, there was only a couple left, and it wasn't something that was being promoted very strongly. So it's not well maintained as a concept. There's better ways out there of owning property. Yeah,
it's almost like a closed corporation.
Yeah, exactly.
Sure. Thanks, Cilna. Thanks, Bruno. And that brings us to the end of today's webinar. As always, it's so good to have both of you with us, and so good to have the viewers with us. And for 50 episodes, like I said earlier, that is no small feat. It's something to look forward to. And let's look forward to the next 50. And as you, the viewers, journey with us, we look forward to having you with us next week for episode 51. My bags are packed. I'm off to Constantia. So if you guys want to join me for the protest, you're more than welcome. The viewers as well. Just joking. But to everybody, thank you so much. And we're looking forward to having you with us next week at Wednesday at 6 o'clock. Thank you. Cheers and goodbye.
Cheers, Chris.
Bye-bye.
Cheers, guys.
Bye.